I'm Dr. Prabha Kotishwaran. I'm a reader in law and social justice at the Dixon Poon School of Law at King's College London. I'm co-editor with several other academics of Beyond Trafficking and Slavery, which is an editorial partnership with Open Democracy. At BTS, we seek to challenge the mainstream media accounts of exploitation and domination, as well as the hollow technocratic policy responses, which are often prompted by businesses and politicians. However, we are also interested at BTS to go beyond critique and ask what's next. In other words, how do we translate our critical voice into one that also engages with law and policymakers, as well as other stakeholders in a meaningful way? With that in mind, we are here today to discuss the Modern Slavery Act of 2015, which was passed by the British Parliament in March 2015, with a view to eradicating modern slavery in the UK. So joining me today to discuss the act is who's head of policy at Kalyan, an organisation which fights for justice for migrant domestic workers. Kate, welcome to King's.
Thank you.
So Kate, you've worked in this field of trafficking and modern slavery for many years now. Could you please tell us a little bit about your experience in this area?
So I have worked in the field for many years. I've worked at Kalyan since 2005. But when I joined Kalyan, my perception was that I was joining a workers' rights organisation. And as a organisation, our focus really has always been on supporting domestic workers to have rights, but also to be able to be informed of those rights and to access them in practice. And it was only the organisation didn't frame itself as an anti-trafficking organisation. I mean, we still don't. We are primarily a workers' rights organisation, and we support all domestic workers to access their rights. Because we think it's quite dangerous when you start sort of saying, well, you have to be treated at least this badly before you can have any rights, because quite clearly if you start denying people rights, their treatment worsens. So yes, we're a community centre. We inform all domestic workers of the rights they have. We run English classes, and if people come to us with even minor infringement issues, we will also support them. So really the organisation only began engaging more in the rhetoric around trafficking and slavery, and we were cautious of doing so in around 2006. And it was really when other people were, I remember Clara Skirvankova of Anti-Slavery International coming and meeting with some of our workers for her UK country report on trafficking. And she just came on a normal day and met some of the workers who were in the centre, and she said, well, everyone I've met today is being trafficked. And again, our stance was a bit like, well, it doesn't really make a difference to the workers whether or not they've been trafficked. There's no legislation in place. And again, it was about helping people enforce their rights, take compensation claims to employment tribunal. For many of the workers I meet at Kalyan, if you speak about domestic trafficking, it doesn't mean so much to them. They strongly identify as workers and they want to push for their rights as workers. In 2006, the then government first told us of their plans to remove rights from domestic workers, and that was following the introduction of the points-based system for immigration. And they had a similar plan to what has now happened, what happened in 2012, which was that domestic workers would come on a 6-month visa. Well, they put out a paper which basically said it'll be either a 6-month business visitor visa, or we'll scrap the route altogether. And so we obviously needed to respond to that. And as so many domestic workers are trafficked, that seems to be the most, you have to also engage with the government's rhetoric and interest. And it was very effective to do so at that time, because 2006 was the bicentenary of the abolition of the transatlantic slave trade. At that time, the government was talking about signing and ratifying the Council of Europe Convention for Action Against Trafficking in Human Beings, both parties were falling over themselves to condemn trafficking, but no one was very interested in workers' rights, particularly migrant workers' rights. So you know, engaging with the anti-trafficking debate was basically a lever to open the door for the conversations we wanted to have about workers' rights.
That's terrific. So Kate, you know, it seems that overseas domestic workers have for long been central to the migration policy of both major political parties in the UK. So tell us a little bit about how the regulatory regime relating to ODWs, as we might call them, has shifted over time.
I mean, it's so. The history is very important. I think it's very hard to understand the visa without looking at the history. It was recently described, I think, by Kate Briddick of Oxford as basically the most disadvantaged immigration category, and I do agree with that. What we've now got is basically a chattel visa where workers are brought to the UK but for the purpose of someone else. They are brought here for the benefit of their employer, and they in themselves have no rights. It's all about the person who they are accompanying. In terms of the history, prior to 1998, overseas domestic workers were basically brought to the UK under a concession. There wasn't really a formal route, but they would get a stamp in their passport just saying permission to work with, naming the employer. And there were never any issues until the worker ran away, and then, you know, their status would be very unclear and they would be the ones criminalised for having no status in the UK and wouldn't be able to access any kind of redress for any mistreatment they'd suffered. So Calian was actually set up by domestic workers to, I think there were domestic workers supporting each other as support groups, and they realised that really structural change was only possible if there was, you know, a legal framework for domestic workers, and that meant recognition as workers in the immigration rules. So Calian was set up by domestic workers to evidence the need for and push for that change. And that happened in 1998 when the then government introduced the overseas domestic worker visa, the original overseas domestic worker visa, which, you know, has been cited as best policy by organisations, including the ILO. It's by no means a lenient visa. There were restrictions. Well, there are restrictions. That visa still exists for domestic workers who entered prior to 2012. There are restrictions on the visa. The worker has to be accompanying an employer for whom they've worked for at least 12 months before entering the UK. They have no recourse to public funds. They have to be in full-time continuous employment as a domestic worker in a private household. So a domestic worker could change an employer, but they would have to find another job pretty quickly because they have no recourse to public funds, and they don't want to be in breach of the conditions of their visa by being out of work for too long. So there were definite issues with that visa, and when we, you know, were working to support domestic workers during those years, there was a framework on which we could build, but there were definitely, you know, people who struggled with that framework, you know, issues around destitution and people, you know, the employers making threats around the visa renewal time as to not support the renewal application. But generally, you know, it worked well. We were doing a lot of work around the time, particularly around employment rights. We were working with the police. We were doing a lot around information for domestic workers, and we felt like there was, you know, with awareness raising, there was an awful lot we could do by building on this framework to allow domestic workers to access their rights in practice. And then, as you know, on the 6th of April 2012, that was all effectively removed with the introduction of the current tied overseas domestic worker visa, which is a visa which is limited to a maximum of 6 months, and the employer to work for the sponsoring employer, and the employer is named on the worker's visa. So there's a strong message there. And the government will say, oh, well, these workers can still access employment law, but it's really hard to see how they would in practice, because obviously the minute they run away, they've broken the immigration rules and they're destitute. They're on the back foot. So it's very hard to sort of proactively take something like an employment case. And if you just look at the case which received quite a lot of publicity a month or so ago of Pamela Turkey, which was the first caste discrimination case which came to the UK employment tribunals. She entered pre-2012, and I think I can pretty categorically say that we won't be seeing that kind of case where the immigration rules are as they are now, because she took her 17 months to even get legal aid. If you're on a 6-month visa, how do you support yourself during that time when your visa expires and you're subject to removal? So there's big issues, and the government's reasons are immigration, and that the original overseas domestic worker visa was a potential route for so-called low-skilled workers, and that's the way the government defines skills, usually around academic qualifications rather than caring qualities. But the government's issue was these so-called low-skilled workers had a route to settlement in the UK, but all the evidence shows that it was a really limited route. In fact, looking at the government's figures, there was no more than 0.5% contribution to net immigration from domestic workers. And I think it's really reasonable to argue that by the time the worker cannot stay in the UK long enough to obtain settlement if there isn't an ongoing demand for their labour, because they have to prove this demand every year. If every year you're making applications to the Home Office to renew your visa, that's a really good way to, just do more checks and check that the employment is genuine employment and it's good. But also, I do think if someone has contributed to the UK for 5 years, I don't think it's that unreasonable for them to be allowed to apply for settlement. And surely there's an argument to be had that during those 5 years, that person was probably quite skilled anyway in the skills this country needs in terms of childcare, elder care. We do have shortages in those areas, but, what about development during their time in the UK? If you don't, and I think it, would be much more positive to recognise that people do have a stake in this country, are building up skills while they're here. And I really think it's only reasonable after 5 years that, at last this person has a chance to get sick. If you're on the overseas domestic worker visa, it's hard even to get sick, because you could lose if you lose your job. Yes, it's illegal for your employer to dismiss you because you're ill, but if you're undocumented, the fact that the employer broke the law doesn't help you so much. Same with maternity rights. The situation is that now we're on this completely dire visa, which, has been recognised really across the board by everyone apart from the government, who have facilitated the abuse and possibly trafficking of overseas domestic workers. And as was debated at length in Parliament, the original visa was not perfect, but there was definitely, it was a lot better, and there was something with which we could really work. Anyone who was serious about preventing the trafficking of domestic workers could then take those basic rights and really help domestic workers access them.
So what has the effect been of the change of rules in 2012? Obviously this could have all sorts of ramifications. It could mean that actually domestic workers come into the country for 6 months, then they leave, or they come in and are forced to return, possibly for because obviously they're taking care of the family that they've worked with prior to coming into this country. There's the risk of becoming undocumented. So what kinds of shifts were you able to map after the rules were changed in 2012?
Well, I mean, the first thing that's important to acknowledge is there's a real dearth of evidence in this area. In fact, no one seems to have any evidence apart from Kalia Ann. And, because we're a small charity, 4 staff, 2 of whom are part-time, we don't have so much evidence ourselves. And one thing the government has done by tying domestic workers to their employer and not recording what happens after 6 months, because we don't count people out, is they've just removed a huge evidence source, because prior to 2012 you could see who was renewing their visa each year, look at the conditions, because the employers have to submit evidence when they renew the visa every year, and they could then you had all this data on people and where they were, and you could do more checks if you wanted. So there's little evidence as to what the effects of the changes really are. We know that the number of visas issued remains constant. In fact, it's increased slightly. So 16,000. Prior to 2012, the majority did come and leave with their employers. Presumably, many domestic workers were fine, and a minority who needed to escape were able to. Post-2012, we only know what's reported to us by workers who come to Kalia Ann. And I think in the 3 years since, I don't have the stats with me, but I think in the 3 years since, between April 2012 and the end of March 2015, we saw 590 new workers. So we're seeing a tiny proportion. But what those workers reported to us is that those who are tied are definitely seeing an increase in abuse, particularly restrictions of freedom, which just can't be coincidence. 3 years to see those same trends does seem to be very much linked to the tying and the subliminal message, I guess, that these workers are owned by their employers. So significantly more workers are reporting having their passports taken from them. I think it's 74% versus 50%. I mean, as I say, both are high, but significantly higher. More report having, being not paid at all. So obviously that restricts their freedoms, having no time off, not being allowed out of the house at all unaccompanied. In terms of leaving the country and returning on another 6-month visa, theoretically that's not possible. Because one of the things that happened when the government changed the rule in 2012, since 2012, people who can bring domestic workers to the UK are themselves supposed to be visiting the UK, because clearly when the government proposed these changes, we said, well, of course, unscrupulous employers will make people stay on underground and then they can do what they like to them. And they said, no, the employers themselves will be visitors. They will all leave within 6 months. In practice, we've definitely seen instances where that's not been the case, including, where the employer has gone along to the Home Office, to the Overseas Entry Clearance Post, explained that they're coming here, the workers coming here with them permanently, been refused a visa, gone back a week later with a different story and been issued a visa. But theoretically, there are checks that a wealthy employer can't just be sending the worker back every 6 months to get a new visa. Again, we've heard from solicitors that they've definitely seen cases of this happening. I guess if an employer is here and staying on and have the worker with them, they might also just keep the worker on undocumented rather than pay for lots of flights and visa renewals and being exposed. We've definitely seen cases where, domestic workers have been kept on undocumented by employers who've kept them on beyond the visa, and the workers not necessarily even held their passport and known what the conditions of the visa are. In terms of the entry of domestic workers, as I say, the numbers being issued visas have remained pretty constant, but beyond that, other than those who come to Kalia Ann, there's no evidence that we know of.
So in light of this, when the modern slavery bill was announced, what was your advocacy plan at Kalyan?
So our advocacy plan was basically to highlight the contradiction between stated claims about particularly preventing modern slavery and this immigration regime, which had been shown to facilitate modern slavery. In fact, was found as long ago as 2009 by the Home Affairs Select Committee in their inquiry into trafficking to facilitate modern slavery. So we wanted to basically highlight that if the bill went through as it was in draft, there was going to be a massive gap, and it undermined the bill. We had a regime in place which is similar to that which we've criticised in countries such as the Middle East. So yes, it was a way to highlight the irony of having this system in place, and we felt, although, basically the way we put it is, this doesn't need to be primary legislation, just change the immigration rules. But if you're refusing to change the immigration rules, then you do need to deal with it in the modern slavery bill, because as stands, you're undermining your own aims, or own stated aims.
So clearly this is a core contradiction within the Act between its purpose and what it's actually ending up doing. So what was the involvement of Kalyan in the processes leading up to the passage of the Modern Slavery Act? There were many points of intervention. And so how involved was the organization in lobbying various parliamentarians? With regard to overseas domestic workers, we were involved throughout. So we obviously briefed parliamentarians and worked with them. Because I guess because we work directly with domestic workers, a group of of whom so little is known about, generally parliamentarians who want to support domestic workers in a meaningful way will ask us what works in practice for domestic workers. Because as I say, we do so much practical advice and support work. So yeah, we were involved throughout. So what were the sorts of political opportunities that Kalyan saw, and what were some of the institutional venues through which you could feel like you could meaningfully intervene? Clearly you're being called upon by MPs and were proactively reaching out to MPs. But were there any other opportunities in this rather difficult political climate, and were there spaces where you could actually express the insights from your long experience with working with domestic workers?
Other than direct meetings and briefings, I guess the other significant place is particularly, we work closely with Justice for Domestic Workers, who are a self-help group, and they, organise a lot of events and demonstrations. And often parliamentarians welcome the opportunity to come to these events, because they do really welcome the chance to meet domestic workers and hear their stories.
So, if we go directly to the Modern Slavery Act, we have Section 53 of the Act, which deals with overseas domestic workers. So tell us a little bit about this section. Explain it to us, because clearly there were many amendments, many iterations of this provision leading up to its eventual passage.
So Section 53 does not reflect what we wanted from the Act at all. What we were hoping for, at minimum. So we sit on the anti-trafficking monitoring group, and together with the group, the group had developed a shadow bill almost, which was like a gold standard bill of what we which the actors in the group would have seen as really ideal. And there was a section on overseas domestic workers in that. The amendments which we ended up supporting asked for far less, because we were trying to be practical, and really just the minimum that domestic workers really needed to not be in a situation where their abuse was being facilitated by their immigration status. So simply the right to change employers and apply to renew the visa. It really wasn't asking for very much. because we were aware that we weren't looking at this within a workers' rights framework, we were looking at it within a modern slavery framework. So just preventing the worst of the abuses. And we came really close to winning it. At committee stage in the Commons, the vote was tied and only lost to the chair. And it won in the Lords, but was overturned again in the Commons. And both parliamentary committees who looked at provisions during the course of the bill made strong recommendations that the rights of domestic workers needed to be reinstated, as did the evidence review conducted by Frank Field. So Section 53 was what we were left with, basically, after the Commons overturned the amendment tabled by Lord Hilton, which would have just given the minimal rights of allowing domestic workers to change employer and apply to renew their visa. And, I mean, in our view, it's, first of all, it comes too late. It only deals with domestic workers who have a positive conclusive grounds decision, so nothing in the way of prevention. It basically leaves in place a visa regime which has been recognised to have facilitated trafficking, lets that happen when the worker's been trafficked, as long as they've been abused or exploited in exactly the right way, so it equates to trafficking, and they're able to escape and get to the right support, so they make an NRM. So they meet someone who is a first responder and can make an NRM referral for them, and the NRM referral is done adequately, so they receive not only a reasonable grounds decision but a conclusive grounds decision. That worker can then apply, so long as they do so within 28 days, and it's not clear if legal aid will be available for this, for a 6-month visa, which limits them to domestic work in a private household with no recourse to public funds. It's just very hard to see how that's going to work in practice. I mean, it was only laid down in the immigration rules 17th of September, so we've yet to really see it coming into play. But it's just such a process and it's just very hard to see how workers who've been trafficked, have no references because their employers were traffickers, can walk into an employment agency and say, I need a job, I can't work beyond 6 months. And reputable agencies have said they would find it very hard you're not going to want someone to look after your kids when, by the time they even get the job, they're way into their 6 months already. It's just not very practical. So our fear is because of the no recourse element, these people will be driven into unsuitable employment and possibly re-exploited. So yeah, it's not great, Section 53. We will be evidencing it. We'll be looking at it in practice and evidencing it. But, it doesn't work. As far as we know, it doesn't worsen the situation of the tied visa. But we've got to look at that as well, because theoretically, domestic workers who've been conclusively identified as trafficked can still get residence permits, because it gives less than a residence permit, which would be a year with recourse to public funds and ability to do any work. So in theory, it doesn't preclude people from a residence permit. If someone was going to be eligible for a residence permit, they would get a residence permit anyway. It's just people who wouldn't get a residence permit, theoretically, can then apply for this. But residence permits are not issued very readily, and it's unclear how those decisions are made. It's personal circumstances, basically, or cooperation with the police. Although a lot of people cooperate with the police, but because their employers have left the UK and there's not enough evidence, the police don't investigate, so they don't get a residence permit. Anyway, we will be, one hypothesis is possibly that fewer residence permits will be issued. So then domestic workers would be worse off. But anyway, we're talking about a very low number who have been conclusively identified. And as I say, it's too little and it's too late. It comes in only after they've been trafficked. Nothing in the way of prevention. The other thing we got from the bill was the Overseas Domestic Worker Review, and you'll know we're still waiting for that. It was the planned publication was the summer. Frank Field tabled a parliamentary question, to which he got an answer last week, which basically said soon. It will be published soon, so we'll see.
So, I mean, it's really perplexing. One can go through reams and reams of documentation around the Act, and it's just striking that the government was so defiant to change this type visa system, despite very clear evidence from several quarters, including parliamentary committees, as you already mentioned, and across the political spectrum, actually, that this exposed domestic workers to servitude. So what do you think is really driving this sheer indifference?
It is completely perplexing, and as a campaigner, it's incredibly frustrating because it should be a no-brainer. I mean, the way a lot was made in the latter debates of the fact that people were abused on the original visa. But, I mean, really, who has a silver bullet to end any kind of trafficking? British citizens are abused. You know, you can't make someone's immigration status safer and then eradicate trafficking for that group. And it's quite clear that people who work in private households are already more vulnerable. But yes, a lot was made of the fact that domestic workers, you know, that the original visa wasn't perfect. So rather than taking an attitude that we have to build on that, it was saying, well, we can't return to that. I mean, it must be immigration concerns and the clash, and it's not only with domestic workers this happens, the clash between this sort of stated wish to do something about trafficking and separate interests within government being very, very keen to be seen to be very tough on immigration. Again, it is strange because with domestic workers, it's not exactly like people were calling for domestic workers to leave. When we get, you know, generally there's quite a lot of public sympathy for domestic workers. You know, we were told when the visa was introduced that it was also just about having a tidy immigration system. But again, that seems very strange. It seems a very strange reason to have, even if you're only looking at political will, to allow yourself to be criticised in this way for having a system that you go from a situation where internationally people are praising your system to condemning it at a time when you're trying to be a world leader in combating slavery. There just seems to be a message that this cannot affect immigration figures, and obviously if people are here less than 6 months, they don't affect net immigration figures.
So were there any unexpected sort of allies that you found along the way in this very difficult struggle? Were there institutional spaces? You know, were there some utterly unexpected outcomes from this process?
I mean, there's always been a broad spectrum of allies who supported domestic workers, and that's been really one of the strengths of the campaigning work around domestic workers. So there were a lot of allies pushing for it was very good to have the absolute support of the Labour Party. The Shadow Immigration Minister, for example, tabled our bills. So tabled the amendments. So that was very good because, as I said earlier, it was the Labour government who in 2006 had proposed very similar changes. They didn't do it, and in 2009 the then Immigration Minister Liam Byrne said he was actually proud of the protections of domestic workers. But it was very good to have the categoric support of the Labour Party. And there were a few individual Conservatives who, came out and strongly supported domestic workers. But I don't think they were really for me, that I didn't think there were really any unexpected allies, because it just sort of seems like such an obvious thing that you should be supporting.
So I guess it's still early days, but do you have some sense of how the Act is being enforced?
It is early days. I mean, as I say, the Section 53 was only laid down in the immigration rules 17th of September. We've not really seen it coming into practice yet. I do think that, there's a risk now that we have our Act and slavery is kind of the idea of addressing and particularly preventing slavery is just sort of put to bed. Well, we've done that, particularly with a very hostile immigration bill going through Parliament at the moment, and things like the criminalisation of illegal working directly flying in the face of a lot of what the modern slavery bill was trying to achieve in terms of prevention and also compensation for victims. We also have concerns about right to rent, for example, about support victims are able to receive. So yes, we're yet to see how the Act plays out. As I've said, we didn't get what we wanted, but even more broadly than that, I think there's a lot of work to be done to make sure it is meaningful in practice.
Mm-hmm. So what's your sense of possibilities for future amendments and institutional reform? I mean, what kinds of opportunities will Kalyan be looking to in the future?
Well, we're going to continue to push on the same issues. I mean, we really have no choice because domestic workers are turning up at our centre every day in a terrible situation because of these immigration rules, that have put them in this very disadvantaged situation. So, we're going to continue to evidence what's happening and to push for change. We haven't yet put in an amendment to the immigration bill, primarily because having had so much debate on the issue during the modern slavery bill and the ODW review promised, I'm sure we will be told to just wait for the review, to the findings of the review. So we hope they will be soon. And in the meantime, we're encouraging parliamentarians to remind people that the review has been promised and that they would like a chance to discuss it in Parliament. And parliamentarians have been raising the issue. So possibly an amendment in the immigration bill. Undoubtedly there'll be legal challenges as domestic workers, continue to be abused as a result of the immigration rules. There's more and more scope for challenges.
Are there models for regulating domestic work that you might consider from other countries where you think, clearly there's a way in which obviously the framework of the Modern Slavery Act, diminishes the political imagination of a social movement and certainly a community-based organisation such as Kalyan. So is there...
There are models, yeah.
So both state-oriented but also community-based models amongst domestic workers to actually prevent not just trafficking but labour abuses. What are your thoughts on both of those issues?
So we're really interested in looking at best practice from other countries. And definitely organising of domestic workers has achieved a huge amount. I mean, really what's been achieved for domestic workers in the past in the UK wouldn't have been achieved without domestic workers themselves. And although domestic workers are in a dire situation in the UK, it wouldn't be the political attention on them if it weren't for domestic workers organising. But, as domestic workers found when they established Kalyan to push for a basic framework, I do believe that without the framework that recognises domestic workers as workers and allows them to withdraw their labour, so, just question you can't withdraw your labour. It is as to how will progressively worsen. So I think that is a fundamental, and then it would be great to look at other things in place. So lots of countries have systems in place that the employer has to commit to opening a bank account for the worker and the salary to be paid into that bank account. We in the UK we now have a model contract, which the government introduced during the passage of the Modern Slavery Bill again to say, look at this amazing contract. But again, it's not really worth the paper it's written on if the worker can't enforce it. The Independent Anti-Slavery Commissioner was recently quoted in the Evening Standard talking about spot checks. Again, inspections would be really good, but domestic workers have to have a rights base and be informed of that rights base, or they won't disclose abuse. So yes, there are lots of models, but I do think we have to get the fundamentals right first, because everything else is just doomed to fail. I mean, why we haven't signed and ratified the ILO Convention 189 is a very good question, particularly given that in 2011, one of our reasons for abstaining was that we had such a good protective visa in place for domestic workers in the UK, which the government swiftly went on to remove. And ratifying 189 would do much for the fundamentals of domestic workers and their recognition of workers as workers. Sorry.
So what would be sort of, say 3 to 5 high impact strategies that Kalyan would be pursuing, and that you think actually other NGOs and academics could support in, campaigning for the rights of migrant domestic workers?
So definitely, we will continue to evidence what's happening. I think that is really key. We will continue to work with lawyers to take legal cases to support domestic workers and challenge the law where it's not protecting them. We'll continue to put pressure internationally, particularly for around ILO Convention 189 on decent work for domestic workers. We'll continue to work with the media, to do awareness raising, to show the absurdity really of taking workers and turning them into victims, which is what's happening with domestic workers. It is what we've been doing, and I can only think most people, when they look at it, say, your arguments are particularly obvious. So I think we just have to continue making them. It will be very interesting to see the results of the Overseas Domestic Worker Review, and looking at how we can work with that. The government has committed to taking on board those recommendations. So that's something we're preparing imminently for, because obviously we've yet to see what it contains, but we hope the recommendations will be sensible and thought out.
So if you could come back full circle to where we started, which is you start out as a workers' rights organisation and are then approached to consider the question of trafficking and to possibly use the discourse in the hope that you were furthering domestic workers' rights. I mean, is there a point at which you would revisit that decision point and say, if you were to do it again, would you have taken on this rather, double-edged sword, and clearly something that has undermined ultimately domestic workers' rights?
I would, yes, I personally would. I don't think it has undermined domestic workers' rights, and I think had we not done it, domestic workers would have lost their rights by 2008. So at minimum, we won rights for 3 years, 4 years of workers, So, and I just don't think there would be any focus on domestic workers politically if we talked about migrant rights. Alone, as I say, we continue to talk about workers' rights, but we have to use the trafficking as a way in, both politically and in terms of legal obligations. So I don't think it's undermined domestic workers. I think domestic workers would have had their rights removed anyway because of the immigration obsession. It just would have happened sooner, and there would be less, the government would be less uncomfortable about it.
Thank you. Thanks very much, Kate, for joining us today.
It's a pleasure.